a shift in public policy. So while the purely discretionary trust was always acceptable in New Jersey, and while there has been no change either in law or regulations, New Jersey has been denying eligibility for individuals with a purely discretionary trust on the basis of the fact that those assets are usable for the beneficiary's benefit. Despite the fact that it's in the discretion of the trustees whether to use the money or not use the money, they are now taking the position that they are not going to provide government assistance where that money could be used in the trustee's discretion for support. As a result, it's imperative that if you have a plan in place and you have a special needs child, that you have this plan reviewed to determine that it's the best, most protective structure under current law. So from a New Jersey perspective, it would be important to have a luxury trust. A trust, again, which says the trust assets can be used to supplement but not replace government benefits. Those trusts are also the form of trust utilized in New York and many other jurisdictions. The trust can be structured in one of two ways. It can either be an inter vivos trust, a trust that's created during your lifetime, which can be available to receive gifts or inheritances from parents or any other individuals. If you do not believe that you are going to be making gifts to a trust and you do not believe there are others who might want to make gifts or bequests to your special needs child, the trust can be a testamentary trust, which is a trust created under your will, which doesn't come into effect until death. If you do have a trust that's created during your lifetime, the trust can be either revocable, where you have the ability to change the terms during your life, or it can be irrevocable. And if you're planning on funding this trust to move monies out of your estate into a place where it's available for your special needs child, it would need to be the irrevocable format. Oftentimes it's important to create flexibility in a special needs trust because depending on when this trust is created, you may not know what level of government benefits your child is going to be eligible for or need. As a result, when you don't know what your child will be able to achieve in the way of independence in the future, you want a trust that's flexible and will work with whatever the situation is at the time that the trust is funded. It's another issue to keep in mind in planning your trust. In funding your special needs trust at death or during lifetime through gifts, there's several considerations to think about. First of all, you need to think about the allocation of assets as between your special needs child and your other children. Assets can be divided equally among the children, or assets can be allocated first to the special needs trust for the special needs child before the other children receive assets. And there are many competing views on which is the appropriate way, and ultimately you need to make a decision that's best for your family. Another decision that oftentimes is considered is whether to cap the amount allocated to the special needs child. Depending on your child's special circumstances, your child may be receiving much of their support in the form of government benefits. Additionally, your child may not have a lifestyle which requires a substantial amount of money. And by allocating money to a special needs trust, you are tying those funds up so that they're not available to other children until that special needs trust ends. So in some cases, it's appropriate to cap the amount allocated to the special needs child so that the other monies can be used sooner rather than later for the benefit of other children. First and foremost, however, in considering funding, you need to make sure that there's sufficient assets available to care for your special needs child in the manner to which you want your child to be cared for the rest of that child's life. In thinking about that, you need to consider the assets in your name and their availability to provide benefits. If you do not believe you have sufficient assets to care for your child, another thing to think about is whether insurance can be useful in providing liquidity. So insurance can be an easy source of cash to fund a special needs trust and can pay over to a special needs trust at your death. What's vital about a special needs trust is a disabled individual can have no control or access to the trust funds. They can't serve as trustee of that trust, and they can't have the power to withdraw monies from those trusts. And it's imperative to ensure that government benefits eligibility is preserved. The next issue to think about for your special needs child is not legal in nature, but it is critical in putting together a plan. And that's considering a letter of intent. What that is, in essence, is a letter of direction to the people who come after you and will be responsible for your special needs child. It's a letter describing what medications have been attempted and failed, or attempted and been useful in treating your child, the therapies that have worked and have not worked, the issues and things in life that may set off your child and the things that may calm them down, and a whole host of other issues that you as a parent may know about your child, but would be lost forever in the event that something happened to you. And what that letter of intent does is it eases the transition from you to the next people who may be caring for your child, because this is going to be a traumatic time for your child. You want to make this as easy as possible. Please remember that state law, as I mentioned at the beginning, can really affect the structure and requirements of the special needs trust. So in our discussion today, we're talking about New Jersey law specifically. And while many of the government programs, such as Medicaid, are federally administered programs, or federally funded programs that are administered by the states, and states are able to create their own set of regulations determining what eligibility requirements are out there. And so state law needs to be considered. And if you have a trust that's in existence for your special needs child and you're moving to a new state, or your special needs child is moving to a new state, you need to consider the effect of the new state's laws on your special needs trust. And it's important that your special needs trust be prepared with the flexibility that's appropriate to make changes to the trust in the future if necessary. In putting together your plan, you may have the most artfully drafted special needs trust and will in existence, but if you have not coordinated your assets with your plan, then you're going to be potentially creating a problem for your special needs child. For example, there are two kinds of assets, probate and non-probate assets. Probate assets are assets that pass under a will. So for examples of those are individually owned bank accounts, brokerage accounts, homes, non-retirement plan account investments, and tenants in common property. On the flip side, there's the non-probate assets, which are assets that pass by beneficiary designation, such as retirement plan accounts and life insurance, and jointly held assets. They pass automatically at one spouse's death or one joint tenant's death to the other joint tenant. Non-probate assets do not pass through a will. So as appropriate as your will may be, if you have not coordinated these assets with your estate plan, you can create traumatic effects on your child's future. So it's important to make sure that in putting together your plan, you coordinate your beneficiary designations and jointly held assets with your special needs trust for your child. You can't ignore the tax effects on your planning. There are two forms of tax to be aware of. First of all, there's the federal estate tax, which is a tax imposed at a rate of 45%. There are two exceptions to that federal estate tax. One is the marital deduction, which is the amount that you can leave tax-free to a spouse. And that amount is unlimited. You can leave assets to a spouse either outright or in a specially created trust called a Q-tip trust for the benefit of a spouse. The second exception to the federal estate tax is the applicable exclusion amount. And that's the amount that you can leave estate tax-free to anyone other than a spouse. Right now, that amount is $3.5 million. We anticipate big changes in federal estate tax law over the next 1 to 2 years. President Obama has already been vocal about his interest in changing the federal estate tax law. The 2001 bill that's in place right now would eliminate the federal estate tax in 2010. In 2011, the tax would come back with a $1 million exemption. Obama has proposed locking in the federal applicable exclusion amount at $3.5 million and locking in the federal estate tax rate at the current 45% rate. There are other anticipated changes as well, but it's early to know what will ultimately be accepted through Congress and ratified by the President. But this is an issue to think about for the future, and you need to make sure that you have flexibility to take into consideration tax laws that are in effect at the time of your death. The second estate tax that's relevant is the state estate tax, and that's imposed at much lower rates, ranging from 4 to 16% under New Jersey law. Again, under New Jersey law, there's a marital deduction so assets can pass to a spouse on a tax-free basis, unlimited in amount. There is also a state estate tax exemption, But unlike the federal exemption, which is $3.5 million, the current state exemption is limited to $675,000 and is not expected to change. In knowing this overall tax structure, you need to think about how the taxes will impact on your planning, and you need to try to minimize your overall taxes. So if you have a husband and wife, and together they have $5 million in assets, counting life insurance, counting equity in the house, counting retirement plan accounts and other assets. In the event of one spouse's death, if you have a sweetheart will that leaves everything to the surviving spouse, there are no taxes imposed at that time, either state or federal. But when the surviving spouse dies and assets are allocated to the special needs trust and other trusts for children, at that point, that federal state tax at a 45% rate and that state estate tax at rates ranging from 4 to 16% kick in. And the surviving spouse would only have one $3.5 million exemption under today's rules, and $1.5 million would be fully taxable. More than that, everything over $675,000 would be subject to New Jersey tax. And what you're looking at in that situation is a tax in the neighborhood of $825,000. And the problem with that scenario is you've wasted the first spouse's applicable exclusion, both state and federal. So it's important that you have wills that make sure you take advantage of both spouses' exemption where it's needed in order to minimize taxes. Next, let's move on to another document that's very important, which is a power of attorney. Power of attorney is a document that is effective while you're alive and allows you to appoint someone to make business, investment, and legal decisions for you if you're alive, but you can't make these decisions for yourself. Power of attorney can be effective immediately, regardless of disability, or can be effective only on disability. The final, most used approach these days is a bifurcated power of attorney, which is effective immediately as between spouses and effective on disability as to successors. But it's important you have that document in place. Healthcare directive is another important document to consider, and that does two things. It expresses your wish not to be kept alive artificially if you're irreversibly and terminally ill. It also lets you appoint people to make medical decisions for you if you can't make these decisions for yourself. And finally, as a result of recent HIPAA legislation, it waives your right to privacy as to the person named under the healthcare proxy document. Life insurance is another specific asset that should be considered in connection with your plan. The face amount of any insurance policies that you own are included in your estate. If you're the owner of an insurance policy or you're the recipient as a beneficiary of an insurance policy, that insurance is taxable in your estate. And again, as we discussed briefly before, it's important that you coordinate your beneficiary forms for insurance with your estate plan. It's important to also consider insurance as a way to fund your special needs trust, as we did discuss before as well. Hello?
Hi.
Okay, heard speech. So
How are you, Faith?
Good. How are you, Kelly?
Okay.
Good.
Just to wrap up, really, it's close to the end. It's important to consider appropriate planning for the special needs child. So depending on your child's specific circumstances, a power of attorney and healthcare proxy may be appropriate for your special needs child. If they're able to handle their affairs and make important decisions for themselves, but you want to be able to help them with those decisions, those documents are critical. Also, you have to think about planning for any assets already in the special needs child benefit. Already in the special needs child's name. So as I mentioned at the beginning, the special needs child can't have more than $2,000 of assets in their own name without affecting eligibility. If there are already assets, whether in a uniform transfers to minor account or in a 529 plan, you need to think about how to handle those assets. With a 529 plan, if there are other children, the beneficiary of that 529 plan can simply be changed. For a custodial account, the question becomes, are there sufficient expenses that need to be paid for the child that can deplete those assets, or otherwise those assets can be allocated to a different kind of special needs trust than the one described before. It's called a first-party special needs trust. Different from the trust we discussed in that there are very specific regulations on what needs to be contained in that trust for it to be acceptable and not affect that child's ability to get assistance. There has to be a Medicaid lien at death, for example. So at the time of your child's death, whatever's left in that trust has to reimburse any agencies who have paid benefits on behalf of that child during life. So that means that basically those assets are going to be lost for your other children in most circumstances and are going to go to the government agencies instead of be retained in your family. There's a bond requirement that must be satisfied. And there can't be an expenditure over $5,000 without first providing notice to the state of New Jersey. Additionally, there has to be a review of the trust by New Jersey, and there has to be annual accounting filed with the state. So obviously a much greater degree of oversight. And wherever possible, you want to try and avoid using these first-party trusts and using the supplemental benefits trust funded by people other than the special needs child with other people's money that we discussed before. The final issue that I wanted to address is guardianship. And where you have a special needs child and the child is approaching age 18, it's important that you give consideration as to whether guardianship is appropriate. If the child is able to handle their own affairs financially, medically, and otherwise, then a guardianship may not be appropriate. But if you have a child who cannot handle their own affairs, who makes imprudent decisions, and who needs guidance, then you would want to consider guardianship. And a guardianship can be general in scope and assume all control over the child, leaving no control in the hands of the child, or can be limited in scope so that the child has the ability to make some decisions for themselves. For example, the child can be given the right to get a driver's license if that's appropriate, or to have a bank account funded with some set dollar amount if that's, again, appropriate. And it takes typically in the neighborhood of 3 to 6 months to complete a guardianship action. And so as your child approaches age 18, it's important to start to get your ducks in a row and get that process moving so that you're in a place to have the guardianship in effect when the child turns 18 right after that, if that's important for your family. That concludes the PowerPoint presentation. I'm happy to answer any questions any of you may have.
Okay, Marty has been collecting questions as they've come in today. And Marty, do you have a question?
I have a question as it relates to a licensed professional counselor working in the school environment. What are some organizations or other resources that I may refer parents to for assistance?
Okay, well, you know what, I'll have it ready. There's an Alliance for Planning that is and there's also Plan New Jersey. I'll get a couple names and phone numbers.
That would be great.
And have those handy.
Okay. Let's see. Another question about cost.
Okay.
I realize that's, a little tough depending on.
Costs are going to differ depending on each family's specific needs, and it's going to differ from attorney to attorney. I can tell you in our office, a typical fee to prepare wills, powers of attorney, and healthcare proxies, together with a special needs trust, whether it's contained within the will or a standalone document, typical fee is $3,000 to $3,500, and that does incorporate beneficiary designations, retitling of assets, and making sure everything works together. But again, there can be circumstances under which that's not the right fee. So if, for example, you've got a substantial amount of insurance and you need to do additional tax planning to move the insurance out of your estate, then the fee can increase. And there are other kinds of planning issues that may come up which would increase the fee.
All right, good. So that's the gist of it. I mean, the questions come in, you can hear me fine, and that's